Have you kindly to mention one matter for inclusion, my lord?
Give it.
Much obliged.
Mine is a premature retirement case which was mentioned last week, and my lord directed that after the file comes to mention it today. So file has come, my lord.
File has come.
File has come, my lord. It is
List it in the next week.
obliged.
If there is a date given by the registrar. It's fresh file. It's a fresh filing.
For jurisdiction. So after that, I went to Supreme Court, my lord, and Supreme Court directed to again for this.
Oh, yes. I remember now. I remember.
One.
Mr. Gopal Chandra goes appellate, my lord. Due to eye problem, he is not. Exactly, my lord. So your lordship he last yesterday, my lord, he mentioned this matter that matter to appear next week, my lord. So kindly check up this matter next week.
As prayed list after 1 week.
Number two.
In item number 2, we have preferred an appeal, my lord. On the last occasion, lordship directed to file the opposition. It was directed to respondent was supposed to file the opposition in respect of this appeal. They have not served the copy of the opposition, my lord, till date, my lord. They appeared last occasion, my lord.
It's not a direction for paper is not given. Formal paper.
What is the date of the order under appeal?
The impugned order is dated 20th April 2017. However, the main order, my lord, would find at page 192, 29th of August 2014. My lord, I'll just indicate the issue is very short, and right now this issue has already been decided. Now, my lord, what has happened is this writ petitioner, they were appointed as
Where is the order of 24, 2017?
24 to page 183.
So this is the order against which the appeal is filed.
Actually, my lord, what has happened is there is an order of 2024 wherein the interim order granted, which was further been extended by this order. Now, my lord, kindly comes to page 192 once. 192.
So what is the
I'll just indicate. Just bear with me for 2 minutes, my lord. So, my lord,
the matter is still pending before the writ court?
matter is still pending before writ court. However, this entire issue, whether this particular rule was ultra virus or inter virus, has already been decided.
So what?
Let it be
Can be informed to the writ court that it
That
is already.
already been. That has already been informed. My lord,
Where have you said that? Show us where is that
no,
your
not in-
statement?
not in this particular matter.
Then don't see we are asked. When we make a query, please respond properly.
Definitely. Not
Make
in,
submissions contrary to the
I
record. We don't appreciate at all.
no, my lord.
Okay. So there is a interim order, extension of an interim order in 2017. Today we are 9 years later, we are examining it. The writ petition is still pending before the writ court. Why should we look into this
So the
matter?
writ
You go
petitioner is
before the
not-
writ court.
Petitioner is not taking any steps.
You are here, you are the appellant. We are not
That's
concerned
why,
with the
why
writ
I am
petition.
saying, with deepest of respect, my lord, why I am
Go and
saying,
mention before the writ court.
my lord, writ court is not entertaining to an
We
extent.
don't know after 9 years of that order.
See, after all, it is an appeal against interim order. So many years the read application is
Kind of
pending. Let
appeal
it be
you want to
disposed
keep
there.
this pending.
No, my lord, my lord, kindly vacate this interim order, send me
No,
back.
no,
Sorry.
you take this plea
All
here.
right, you argue why the interim order should be vacated.
Yes,
Tell
my
us
lord, because kindly hear me for 2
after 9 years why it should be vacated, first of all.
There is a change in the situation because 9 years back situation.
So if the
was
change, if there is a subsequent development, inform the court. Why in the appellate
that
forum?
in other matters we have duly informed.
See, we are not concerned with other matters. Don't try to just,
I bow down.
don't
But
do that.
I bow.
Confine yourself to this case. Go and inform the court if there is a subsequent development. We are giving you liberty.
So affidavits are complete before the writ
Allow me
court.
to file a modification application.
Whatever you
or
do, who is
written
stopping you? Who is stopping you?
Very well.
After some argument, the learned applicant for the Yes.
Yeah, please, Your Lordship. Well, my submission is this, my lord. I was initially appointed in the year 1980, my lord, as assistant accounts officer. My lord, in the year 1991, my appointment was approved by the finance department. My lord, in the year 2001, my lord, the post of assistant accounts officer was upgraded as accounts officer, and I was appointed as my lord, accounts officer on condition that, my lord, that I will not be entitled to get the benefit of the career advancement scheme. But my scale of pay, the post of accounts officer, has not been approved by the government of West Bengal. That's why, my lord, I have been reverted up in 2008, my lord, in the post of assistant accounts officer. My submission is this, my lord.
You became accounts officer on?
On, my lord, on 1980, my lord.
Can you give us the date, please?
My lord, 13/11/1980.
13/11?
13/11/1980.
80?
80.
Accounts officer?
1980, my lord.
No, no, no. That is your assistant accounts officer.
Assistant accounts officer.
We are asking you accounts officer.
Accounts officer. Your
Yes.
lordship, kindly come to page 46.
Please give us the date, sir.
Date, my lord, I'm saying. His date, my lord, 4th August 2001. 14th August 2001. Page, my lord, 46.
Let us see that order.
46 last portion. Volume 1.
Yes.
And my lord, kindly come to page 77.
Yes.
But they cannot punish me in both ways. I worked as accounts officer from 2001 till my retirement, but I have been denied the benefit of the scale of pay of accounts officer. At the same time, my lord, I have been denied the benefit of career advancement scheme, which they have admitted in their letter. Had I not been upgraded, I would have got the benefit of 10 and 20 years benefit of career advance scheme as assistant accounts officer. Since I work up to 2008, from 1990 as my lord,
The CAS is applicable to the corporation.
my lord corporation.
CAS is applicable to the corporation.
Yes, ma'am, applicable.
There is no dispute on that.
No, there is a government applied one of that. That is an annex. That government is
So the Honorable Single Judge has directed for payment of some interest. What is that interest on?
my lord,
The writ court's order, we have found that some interest has been awarded. For what the interest was awarded?
my lord, let them pay the benefit of career advancement scheme. Let them pay me that. At
Yes.
least one.
There was a delay in the payment of the arrears.
Areas on account of what? That's what we are asking you.
But,
Areas on account of CAS or areas on account of his upgradation, of course.
but his upgradation malad was not allowed by the government. So they fixed a scale of the assistant accounts officer as it was then. And there were some areas
With effect from 2001.
2001 because ROPA became applicable.
Yes.
So whatever areas was there
Very well.
that he was entitled to get as an assistant accounts officer.
Yes.
There was some delay in payment of those areas, but on which the interest was directed. That interest has been paid. He has accepted that interest.
No, but then why he is being deprived of the benefit of CAS? That is the issue that he is raising now.
But, he was given an upgraded scale. If your lordship kindly sees, but if your lordship kindly comes back to page 71, not 71, I'm sorry, my lord,
46.
46, I'm sorry.
No, but this he has not been allowed to continue with this benefit because the government did not approve of this benefit. You see, the third paragraph says no communication of decision was made by
Yes.
the government.
Yes,
So therefore, he says subsequently, if this was subject to approval by the government,
yes.
he says subsequently government did not approve it. Said,
But
why did you do this on your own?
But subsequently in 77, at page 77, if your lordship sees, Malad, his annual increments and everything has been given.
No, increment is given to everyone. Increment has nothing to do with stagnation. Increment is annual. It's a very paltry sum occurring on a fixed date every year. That's a different thing. The CAS is to overcome the stagnation because he's.
If your lordship kindly sees, Malad, the last paragraph at page 77,
Yes.
since the pay of Sri Swaraj Kumar Dotto has to be reversed.
Has to be.
Yes.
Has it been done?
But to fix this, that is what is being done, Malad, in this, if your lordship sees, Malad, the unrevised scale of 1500 to 3410 to fix up his pay revised scale of pay at 4,800 to 10,925 as per order dated 14/10/2005 of corporation number size. His pay is lately fixed at 8,000 on 1196 and revised scale of pay of 4800 to 10,925 notionally up to 2007 and thereafter actually as per government order 2000 order dated 2007 to draw in arrear pay
this increment is being shown on the revised scale.
on the revised
On the revised pay.
Yes.
Assistant account officer.
No, that's not the
Assistant
point.
account officer.
So you said even if you continue as the assistant account double AO,
He has
you
got
should
all-
be getting the CAS benefit.
Yes.
That means revision. So revision is directed by this 70
is there.
this order of the corporation at page 77. Then what remains?
But I have, my lord, the pay has been fixed in the scale of assistant accounts officer, not
Has to be.
career advancement scheme. Career advancement scheme, and after 10 years, I should get higher scale of pay. My scale, the pay has been fixed 8,000 in the scale of assistant accounts officer. That's true. My lord, I was upon 1980. And
No,
it has been fixed-
higher scale does not mean the scale of the next promoted post.
Yes, my lord, higher pay. Next higher scale. After 10 years.
Page 46 benefit is not getting.
Career advancement scheme.
So
If I stagnate
Career
for
advancement
10 years and 20 years, I'm entitled to get two benefits, my lord. That is my submission.
Did you ever apply for such a benefit? Has such benefit been rejected? See, they have placed you in a revised scale for the post of assistant accounts officer.
But this has been done after my retirement. I have been allowed, I retired in 2008.
That
and
we have
this order
seen.
has been
That
passed
we
in
have.
2008.
That we have seen.
After my retirement, I have not prayed for that. After my retirement, I have prayed that. My submission is this, my lord. They cannot punish me in both
What
ways.
was your prayer in the writ petition? Let's see.
Petition in my prayer to give me the benefit of the scale of pay of accounts officer. My lord has the power to mold the prayer.
Where is the prayer in your writ petition?
Page
Let us.
37.
You are only seeking revision. You are only seeking revision of pay. You have not sought any benefit of CAS scheme. And that appears to have been granted by the order of the corporation at page 22/4/2008. This order. There is no prayer for CAS benefit. How it can be granted?
Because you can mold the prayer, my lord.
There has to be an occasion. If it is a consequential thing or something like that which is apparent, here is a claim which you are required to set out substantially for them to respond. Without such an opportunity, how the writ court can direct? Therefore, we ask you whether you have ever requested them for such benefits. See, now they say this upgradation business we cannot do it because the corporation cannot travel beyond the government's mandate, which says it can't be done. They have revised your scale. Now you say that CAS should be, but where is the demand and refusal for CAS?
My submission is this: they have revised my skill of as assistant accounts officer.
Correct.
Assistant accounts officer.
So, but you have only paid for revision.
But kindly consider that.
You have not paid for any relief beyond revision. You say revise my scale as per ROPA so and so, which they have done. The correctness we don't know. It may be correct, it may be wrong, but they have done it. And this writ petition is of which year?
2009.
2009.
2009.
So you have not even challenged this order of 2008, 22/4/2008. So how the relief can be granted? Molding the relief does not mean that everything the court will do for you.
No, but kindly see the injustice which has been done.
But kindly see, you are required to raise an issue of injustice. Then only justice can be meted out to you. Neither you have sought quashing of this order of 22/4/2008 that it is a wrong benefit granted, nor you have made a prayer for CAS. So how the writ court could have granted these benefits to you?
The revision of the accounts officer, that is what he has prayed for.
How it can be granted? And you want revision of the post of accounts officer. How it can be granted? You know that you have been deprived. Unless this order of 22/4/2008 was challenged, can you get this relief? You cannot. At best, what you can do today is move the authorities for grant of CAS benefits. That is the best you can do because that's a prayer you have never made.
Well, given liberty, you will pray for them. Yes, that much can be granted. So like
Yes, we'll dispose it off. After
Now, fourth, I appear for the unsuccessful writ petition. But in this matter, my lord, a disciplinary proceeding, the propriety of the disciplinary proceeding, my lord, is the subject matter of challenge. Now, on the last occasion when the matter was extensively heard, my lord, your lordships were kind enough to direct my learned esteemed friend to supply, my lord, the policy of the bank, my lord, on which is the edifice of this entire disciplinary proceeding was built upon. Now, my lord, he had supplied, it is running into 300 pages, if not more. My lord, we did not find anything, my lord, which really, my lord, runs contrary to our submissions as well as the pleading, my lord, made in this proceeding. Now, my lord, the case in nutshell, my lord, is this. Next day.
We cannot proceed in a nutshell now.
Yes.
You have to open things up. Very quick. Because this bench did not hear you on the last.
Yes, yes, yes.
Either you have to proceed fully or we can take it up in the next week when the bench is available, hopefully in the next week.
Yes, your lordship, sitting with Justice Mishra, had heard the matter extensively.
Lists after 1 week.
Next week.
Any date as per your convenience.
Presumptuous of me, my lord. On the last day, yesterday, your lordship was of the prima facie, that 30th, my lord, possibly there are other matters. That is why 1st July.
Any date,
Yeah,
1st July.
Deeply obliged.
We are here, every date is convenience for us.
Now 5.
Your Lordship, in item number 5, I am from the petitioner, Your Lordship. Mr. Sukhasai Chatterjee will appear in this matter, Your Lordship, but he is appearing in item number 1 at court number 18, Your Lordship. Kindly make it a short pass for Your Lordship.
Let us see. Hey,
जब I appear for the respondent.
tag change करो. सब पेज निकल जाए.
ना.
Lord, we are for the respondents in this matter, Lordship. Yes, sorry.
Take it up tomorrow.
So was this matter, Lordship, only one submission? Can it be next week, Lordship?
No, sir. Tomorrow, sir. As prayed by the learned counsel.
Six. I am for the appellant bank, my lord. Today is, my lord, fix the date for giving judgments, my lord. Kindly look at the order dated 13th May, my lord. Last order.
Then let it come in the next week. Let it come in the next week. That bench is not available today.
Yes, same day, my 1st July.
As prayed, 1st July.
Number 7.
I'm praying for short passover. I'm for the appellant.
Let's see, madam. Start. Whoever is to come will come. Don't panic. Who is, you are for the appellant, and who is for the respondent? You are appearing.
Your Lordship is for
What is the issue? Just tell us.
But ISI,
ISI.
Indian Statistical Institute. But my client had joined as a professor. No, he joined as a initially as an assistant professor, then as a professor, then as a distinguished professor, distinguished scientist, then a director for 5 years. But there is a
These are separate periods of his service, or it is
continuous.
continuous?
But the science of refrigeration owes a lot to this gentleman all over the world. Now I'm not. Then there is a standing order in ISI, which had provided for entitlement to gratuity without a ceiling. At one point of time, gratuity was calculated on the basis of monthly wages. Then there was a ceiling or cap on entitlement. So, regardless of the number of years of service and regardless of the ceiling, one would be entitled to gratuity in ISI. Now, not with the incorporation of the GPF gratuity scheme, ISI introduced an option exercise to be undertaken by the employees. My client opted for CPF cum gratuity, so he relinquished pension. Now, because of certain audit query in 2015, not all the employees were getting in excess of the ceiling limit on
The Payment of Gratuity Act you are getting.
I was getting
Under the scheme or under Payment of Gratuity Act?
not under the payment of gratuity, under the standing orders of the
Under
ISI.
that standing orders.
This was continuing even after 1972 Act was enacted. The Payment of Gratuity Act was enacted. In 2015, there was an audit query as to why the employees of ISI are getting more than the entitlement under the Payment of Gratuity Act. This, the institute replied by saying that we have our own standing orders which provide for better terms of gratuity. And this gentleman had opted for these better terms of gratuity, surrendering his pension option. Now, since this issue remained unresolved, somebody in the ministry said, no, you should be complying with the Payment of Gratuity Act and not on hard terms of gratuity, better terms of gratuity. So my client was paid the ceiling limit of gratuity, but what was actually calculated for him has not been disbursed to him. This issue in the writ petition has been decided in my client's favor by holding that even in the Payment of Gratuity Act, there is a provision which permits better terms of gratuity to be paid to the employees. From this judgment, the appeal arises.
What is the delay in filing the appeal?
Lordship, there is 79 days delay.
Can 2.
Can to your Lordship. Controllership.
If your lordships may kindly have a look at page 71, that's the institute's reply to the audit. This will give a brief indication of the dispute between the institute and the central government. Page 70 is the objection of the audit. Please see what is page 70. Excess payment of gratuity rupees 1.06 crores, because not all other employees were retiring with higher gratuity. The Payment of Gratuity Act was enacted to provide for uniform scheme for payment of gratuity to employees. The Act has been extended to the whole of India. The change in the definition of employees brought about the Payment of Gratuity Act, which made teachers entitled to so and so. Then please see, further amendment was brought about by the Payment of Gratuity Amendment Act, by which the maximum amount of gratuity payable to an employee was increased from rupees 3.5 lakhs to rupees 10 lakhs with effect from 24th of May 2010. by notification of the ministry. The Council of the Indian Statistical Institute in June 1978 noted that Payment of Gratuity Act 1972 and the rules made thereunder by the Government of India were applicable to the employees of the institute. Audit scrutiny of March 2015 revealed that the institute computed the gratuity in respect of its employees, CPF subscribers, as per the procedure laid down in the said act, but did not limit the payable amount to the maximum ceiling of 10 lakhs as laid down in Payment of Gratuity Amendment Act. Test check of sanction records, payment vouchers and ledgers of ISI Kolkata for the period from 2011-12 to 2014-15 revealed that the institute had paid an excess amount of rupees 1.06 crores during the period from 2011-12 to 2014-15 towards gratuity to 9 employees on termination of their employment. Details are in Annexure 1. The institute stated April 2015 that the calculation sheets were checked by its account section and thereafter sanctioned by the competent authority. The institute was unable to provide any justification for non-compliance of the provision of the Act of 2010, Amendment Act 2010, regarding the maximum amount of gratuity payable to an employee. Now, please come to page 71. There's the reply. The standing service orders came into effect in the institute in the year 1963. The standing order governs the conditions of service of the workers of the institute. Before the Payment of the Gratuity Act came into force in the year 1972, the workers of the institute used to receive payment of ex gratia compassionate gratuity after rendering 24 years of service as per Appendix 6 to SSO. After introduction of Payment of Gratuity Act 1972, it became inevitable for the institute to amend the ex gratia payment in line with the Gratuity Act in the council, and accordingly an office order to that effect was issued by number so and so dated 24 June 1978 with an exceptional clause, Rule 7, which provides that notwithstanding anything contained in these rules and in all matters relating to gratuity which are not covered by these rules, and in any matter for which any of the provisions of these rules are found to be less favorable than the provisions of the Payment of Gratuity Act and the rules framed thereunder as amended from time to time, the provisions of the said act and rules to the extent of such inadequacy or stringency shall apply mutatis mutandis. The institute is following the contents of Rule 7 whenever it is required. Meanwhile, when the CPF contribution was raised from 8.63% to 10% of the pay and the admissible dearness allowance, the nodal ministry was requested to bear the extra matching fund for CPF contributors. Incidentally, the nodal ministry, while approving the additional fund required for the additional matching CPF contribution, gone through the existing system being followed in the institute within number so and so of 1997. Accordingly, reply was sent to the ministry from this end, dated 1/1/1998. The nodal ministry in turn referred the matter to the Department of Pension and Pensioners' Welfare for obtaining their views. Categorically mentioned that the Department of Pension and Pensioners' Welfare deals with matter concerning to the central government employees only and not concerned with the matter regarding switching over by ISI from ISI CPF gratuity to ISI CPF rules, vide letter dated 15/1/1998. It is therefore requested to take action according to the existing provisions under the ISI Act. Since then, the institute is maintaining the payment of gratuity under better option available under Rule 7 of the Office Memorandum of 1978 and the Payment of Gratuity Act without any ceiling limit.
So, in view of Rule 7, is this justified?
Yes, that's one. But one, Rule 7 said that we will not pay lesser than the Payment of Gratuity Act. That was the purpose, because this was aligned in terms of the Payment of Gratuity Act. Please see, it's quoted there in the first paragraph, probably the 5th line from the bottom of that particular paragraph, beginning with the words notwithstanding anything contained. Notwithstanding anything contained in these
What
rules.
about the ceiling of 10 lakh rupees?
That
Can you pay more than that?
That not the Payment of Gratuity Act itself provides for better terms of gratuity. And my client, on invitation of option to be exercised.
Where is that provision in the Payment of Gratuity Act? Payment of Gratuity Act नहीं होगा.
এই দুটো আছে দিয়ে দিন। দু কপি আছে। But section 4 deals with entitlement and eligibility towards gratuity. Please come to section subsection 3. The amount of gratuity payable to an employee shall not exceed 10 lakhs rupees. 4. For the purpose of computing the gratuity payable to an employee who is employed after his disablement on reduced wages, his wages for the period preceding so and so. 5. Nothing in this section shall affect the right of an employee to receive better terms of gratuity under any award or agreement or contract with the employer.
So standing order falls under which category?
But it's a contract of employment.
The standing order is also on record.
But no, it's not on record, but we have copies.
Let us see. Why don't you check from the book list if it is there or not? If it is not there, then what is the point in looking at it?
But may I just not place not unfortunately the other copies. See. There is a provision of gratuity fund at page 14, 32.0. (32.1) says the institute maintains a gratuity fund from which gratuity may be paid in accordance with the orders contained in Appendix 6.
It's not asking you to show us the procedure
No, it's a
because the exception is with reference to an agreement or a contract. So with this, whether this falls as under the category of agreement or under the
conditions of service will not is automatically not contract. They're all conditions of service, and not every employment is a contract except government service. That's not 67 Supreme Court 1669, 1889.
you are relying on 32.1.
Yes. 3.1. The institute maintains a gratuity fund from which gratuity may be paid in accordance with the orders contained in Appendix 6.
Where is Appendix 6?
No, Appendix 6 is not it's not paginated, but just after page 26, 27. I am sorry, after 28, your lordship will be pleased to find at the bottom 2. It's marked as 2. After page 28.
Regarding this person's foregoing the pensions and all these things, are these recorded in your order?
Yes, everything recorded.
In order, and that is the agreement. If you realize that as an agreement,
But I say it's
this foregoing pension and other.
It's Rana case of Estopel also.
So this specifies for payment of gratuity, but what is the quantum? That is the issue.
Please come to the note there under
Yes.
just after rule 1. Every worker who has completed 1 year of service.
1 at 32.1.
No, just in appendix 6.
Yes.
After page 28.
Yes.
So just after the eligibility clause, your lordships will be pleased to find that it mentions the worker shall be granted a gratuity at the rate or rates hereinafter mentioned. Just after A, B, C, D, and F, shall be granted a gratuity at the rate or rates hereinafter mentioned. And the rates are mentioned in clause 7 at page 3, just 2 pages thereafter.
No, unfortunately, I have not been able to locate what you are saying.
No, just 2 pages after that one.
After the appendix.
Yes.
2 pages after that, we have appendix 7.
But there is internal page 3, just 1 page.
Another thing is, you see, Statistical Institute being an autonomous body, they are empowered under this 5, subsection 5. And with regard to that, they have framed a scheme for this purpose itself.
There is neither any maximum limit nor any minimum limit nor any rate has been specified. So there is no condition of service as regards the quantum. There is a condition of service that it has to be paid, but the rate has been left variable to be paid from the gratuity fund in accordance with the orders contained in appendix 6.
Right.
Appendix 6, we are unable to locate that there is any amount.
There is a method of calculation. Please come to in appendix 6, there is a schedule. The page is numbered as 4.
Yes.
Class of cases, rates at which gratuity may be sanctioned per completed year of service or part thereof in excess of 6 months.
Yes.
In all cases covered by rules 1A to F, 1A is superannuation, 15 days wage.
So the entitlement of the writ petitioner is as per Schedule A.
As per schedule.
Where have you stated this? Where the Honorable Single Judge has taken this into consideration?
Now, if your lordship will kindly have a look at page 78. Please come to page 76 and 78. But I just show not the correspondence and then not come to the finding. In reference to letter of 2016 of Dr. Pal, who retired on superannuation in 2015, it is informed that in the note of retirement benefit sale dated 14 July 2015, mentioning the date of qualifying service and amount of CPF gratuity was calculated tentatively, but at time of settlement of his retirement benefit in the original statement of calculation of CPF gratuity of Dr. Pal was made based on the actual length of qualifying service in the institute, and the amount of CPF gratuity incorporating DA was determined on 38 years, 9 months, 4 days, that is 39 years amounting to 38,92,000 respectively, copy enclosed. So this was done without a cap or a ceiling.
No, the ceiling is not relevant. See, if you are relying on the standing order, then what does the standing order guarantee? It guarantees that gratuity has to be paid. Insofar as rate is concerned, it says it will abide by Schedule 6, Appendix 6. You say in Appendix 6, the maximum rate is specified in Schedule 1. So where can you show that the amount paid to him, 38, 39, whatever lakh rupees, is in accord with Schedule 1?
Not Schedule 1, Appendix in Schedule 1 to Appendix 6 says that gratuity shall be calculated at the rate of 15 days for year of service.
No, that's the maximum.
That's right. Not some
It does not say it has to be. It says that is the maximum.
Not some institute there could be 20 days, some institute there could be 30 days. Not it's 15 days wages for year of service.
Yes.
Now, not this does not refer to a cap.
See, it starts with the word maximum.
Right.
Schedule 1, read Schedule 1.
Maximum, yes.
Yes, the maximum rate at which gratuity can be sanctioned
is 15
so
days.
it cannot go above this.
It cannot go above 15 days wages.
So therefore, from the sanction order made in respect of the petitioner, how do we find out that it is within this maximum ceiling specified in Schedule 1? Where is this stand taken by you?
Not that's what they have calculated themselves. Not page 76.
No, this does not show that what we are asking you. This shows it is based on his length of service.
Right.
But it does not show that the calculation is with reference to 15 days pay.
Not it's not of course not there. It's 39 years with the DA. Not this will come to not. It's only an arithmetical calculation, not which they have calculated.
No, we are not on arithmetic. We are on whether it has been done like that or not.
Not, may I show page 80?
Yes. Yes.
But it's part of their own calculation.
That is the calculation.
Yes, which begins at 79.
Yes.
The retirement benefit cell has calculated. Please see note serial number 6 at page 79. Net qualifying service for gratuity at ordinary rates from 76 to 2015, 38 years, 9 months, 4 days.
Where is the 1 day's wage?
Not page 80. Basic pay, 1 day's wage is equal to A divided by 26 days is equal to B. Basic
So
pay is
B multiplied by 15 in the next one.
that's to be multiplied by 15.
So that means 15 days.
15 days. Basic is 79,000, DA is 94,010. Total comes to 1,73,000. For 1 year, gratuity would be 99,813. So for 38 or 39 years, it comes to 38.92 lakhs. 10 lakhs is the cap. These 10 lakhs they had released and awaiting the final decision of the ministry.
So page 80 is you are not disputing.
No, I have not disputed.
So that is this 10 lakh you are admitting.
10 lakhs they have released to my account. 38 lakhs is their own calculation. I seek for refund, release of the balance amount.
And where is yes, what is your stand?
My stand would be this, Lord, that Lord, after coming into force of the Act, Payment of Gratuity Act, the Lord, SSO, that is Lord, Standing Service Order, loses its effect. Therefore, calculation was erroneous. The calculation which was made by the IS.
Why does it lose its existence? There is a provision in the Payment of Gratuity Act, or after the Gratuity Act, you have issued some circular or notification saying that SSO shall now henceforward not be applicable. Why it is not applicable? Merely for the saying we cannot accept. So what is the foundation on which you rest such a submission that it is not applicable after coming into force of the Payment of Gratuity Act? From where do we get this? How you support this submission?
Lord, kindly see, Lord, the SSO was followed prior to coming into force of the Act.
That's a different thing. That we are not. That's
But
not
Lord,
the issue.
After the enactment was made by the Parliament, Lord, Lord, in accordance with the provisions of the Act, Lord, all employees were treated. All employees.
Therefore, we are asking you, show us what is the basis of such submission, which provision, says that henceforward any agreement, contract existing with an employer-employee that will be deemed as redundant, henceforward all have to comply. What is the basis of making such a
But if
submission?
your lordship kindly considers our opposition filed before the learned trial court,
No, just show us from
No,
the
from the
provision.
statute
From
itself.
the provision you show
That
us.
is the authority do not have any power.
just a minute. বের কর opposition টা একটু বের কর relevant জায়গা to বের কর।
Standing in the opposition is that the standing orders apply to the employees. That's page 91.
Let him make his whole case is on the premise that after coming into force of the act, this cannot continue. So we are asking him to show from where he is making this submission.
একটা দে opposition টা দে just a minute let him go.
You examine it. You examine it. The learned senior. Yes.
I'm grateful.
Mr. Majumdar's book is.
On what basis payment of gratuity act করে কি এসএসও যে অ্যাপ্লাই করবে সেটা number 9
Application for condonation.
And one is
There's an application for condonation. Huh? Which application? Can?
There is an application for condonation of delay loss.
Can number?
And one is the application for condonation of delay.
How many days?
76 days.
And can 2 is for stay.
Can do is first.
Good. How long you have worked there?
Lordship, I have worked, Your Lordship, in the Rogi Sahayak Kendra at the National Rural Health Mission, Annexure P2, Your Lordship, in the
How long you have worked there? We
have-
asked you a simple query, sir.
Your Lordship, I have worked there, Your Lordship, since
Where is the impugned communication of 27/3/24?
After 2016.
Where is the impugned communication of 27/3/24?
kindly come to the page number 80, Your Lordship.
1016 is it?
That is the order which they had challenged in the writ petition.
Appointment, Lordship, issued an appointment letter.
Page number 81
Of
is, Your
joining
Lordship,
at
the appointment
25th
letter.
of January.
No, we are asking him where is the order impugned before the writ court.
Lordship, it is attached with, Your Lordship, the main
27/3/24, annexure 13 of the writ petition. Where is it? Which page?
No, page 13.
page.
Lordship,
Or show us your
Lordship,
appointment letter, annexure P4.
Lordship,
P4, where
page
is
196 is the termination.
196?
196.
And
That is in the second volume, Lordship. Lordship, these 27.3 P14 is 195 and 196.
and the appointment letter of
I'll just check.
8th October 2016. This is not the impugned order. Impugned order perhaps is page 195, P14,
195 is probably
27/3/24.
27.3.
That is the letter which you had challenged in the writ proceeding.
Your Lordship, the show cause notice that was also challenged before the concerned read court, Your Lordships.
The show cause notice P14.
Yes, Lordship.
Sir, can you give us some detail?
Since Your Lordship,
No.
I'm
Come
headed by-
to page 195. Come to page 195.
yes,
195. Thank you. That was
to draw your attention in a matter that Keka Shamanto Rogikulan Samiti Hugli is absent from her duty several.
So this is the show cause.
this is the communication to the NGO who had placed her.
So appointment is at page 81. You have challenged this 27.3.24 and 33.20. These are the only two. Yes, so what is wrong with the red court order?
Lordship, since Your Lordship, I am led by Your Lordship, Mr. Subhoshi Chatterjee. He will argue on the point, Your Lordship, the maintainability, since Your Lordship, the petition that was dismissed
Yes.
on the ground that the respondent authority are not falling within the purview of Article 12.
That's all. There is nothing else in this.
Since her appointment that was admittedly done by the Your Lordship, the NGO, with the help of the NGO, but
With
she
the help
served
of the NGO by
Your Lordship, appointment letter shows Your Lordship that her appointment that was
51,
done by the Chingra Thak,
the NGO.
it's an NGO.
so not for, it is by the NGO. Appointment by the NGO and your dismissal also by the NGO. Page 196. Why the state, how the state is going to be involved in this at all, in any way?
Since Your Lordship, she served and she discharged her duty at the Your Lordship, the government premises.
Yes.
And Your Lordship, although the appointment that was done by the NGO, but her duty and the functions, whatever she discharged under the instruction of the Your Lordship, the authority, which falling within the purview of Article 12. First, Your Lordship, and second, that the appointing authority is discharge the public function. And in terms of the Your Lordship, the Sagar Thomas judgment and the Ramakrishna Mission judgments, Your Lordship, there are points, Your Lordship, my senior can assist Your Lordship in this point.
No, today we are just taking it up with for final. No further adjournment. Enough adjournment in this matter. No further adjournment. This pendency is not helping anyone. This person is already out of the job for now 2 years. Why to keep it pending? He was appointed by an NGO, dismissed by an NGO. So that's all. There is nothing else.
May I, Your Lordship, pray 1 day accommodation? Your Lordship, I'll argue on that point. Your
Not,
Lordship.
not
Since Your
even
Lordship,
1 minute. Please complete right now. We have heard you. You have said that he was lending his services to an establishment which is state within the meaning of Article 12. And they were performing a public function. That's all. Anything else?
Your Lordship, the appointing authority discharge the public function, Your Lordship.
Who is the appointing authority?
Appointing authority is the Your Lordship, the
That
secretary.
you have already said. That we have already said.
And to the extent the service of the Your Lordship, service rendered by the petitioner at the government premises, and the service that was discharged by the petitioners under the instruction of the authority, the hospital authority, because he was engaged there, and there was no as such, Your Lordship, complaint by the authority, and there was no.
Even if there was complaint, whether there was complaint or no complaint, that is irrelevant. That's not an issue here. That is not an issue here. How you can claim anything against the government? What is the consequential prayer that you have sought? That it should be quashed and to resume your posts in the Rogi Sahayak Nadipur Rural Hospital. How it can be done?
Block health.
It cannot be done. It cannot be done. That's all. Yes, take some. Heard the learned.
I appear for the appellant, my lord.
My lord,
The Section 5 application.
I appear on behalf of the WBACDCL, my lord. In this matter, WBACDCL, the respondent, West Bengal State.
Sole respondent.
Sole respondent, my lord. Two aspects, my lord. I require some time for seeking some more instructions from my client, and I am led by Mr. Amitesh Banerjee, senior advocate.
The Section 5 may be hard, my lord. It's a delay of 41 days, lord. It was because the matter was decided before the vacation, Puja vacation, and it was filed after the Puja vacation. A certified copy applied before vacation, lost, another certified copy was applied. 41 days.
My lord, I leave it to my lord.
What is the application number?
The can 1 is the Section 5.
No, can 2 is Section 5.
Number will be
41 days delay.
41 days, can 2. 41 days delay, my lord. And the other application is for release of the my lord, admitted dues.
Where have you said about the certified copy being lost?
Paragraphs 4 to 10 of the application.
No, regarding the certified copy being lost, misplaced.
I'll point.
Yes, paragraph 5. Yes, take down.
I'm filing the affidavit of service, it may be kept with the record.
At the top, affidavit of service taken on record.
Grateful, man. 7.
Section 5 उसमें तो 75 या कुछ days.
Lordship, in this matter, I have been requested by the Police Recruitment Board to appear on behalf of them. Lordship will kindly Give me a week's time.
Order has been complied with by the police recruit.
Anyway, let me take instructions.
Publication of panel was the order. Panel has been published. Second round of litigations are
Yes,
going.
on the last day we were informed.
Yes,
about
yes.
What will remain?
Lordship, they
Hey,
have just asked
she's-
me today.
No, therefore let us keep it in the next week.
Yes.
If nothing
Lordship,
remains, then what?
no,
Why 3 weeks?
Lordship keeps it next week.
As
Let's-
prayed.
Action. That-
Well,
matter, my lord, I appear on the respondent, my lord.
My lord, I am
But
the
one difficulty, my lord, I must be candid, otherwise I'm ready. The lordship last occasion passed an order, my lord, directing them to file the copy of the additional documents, application and the memorandum of payment they have served. I have also prepared the affidavit in opposition, but I have served them also. But unfortunately, my client, due to fever, he could not come. Today it has gone for affirmation. But otherwise, I'm ready, my lord.
Tomorrow?
Tomorrow.
Not today.
I'm not convinced.
My lord,
So it is already exchanged. Only filing is being done.
Only fine. Affirmation.
my lord, it will be day after tomorrow.
As prayed by learned advocate.
Why I have prayed for day after tomorrow? My lord, they have referred to a document in their opposition, which is sub judice before the coordinate bench. My lord, it will be taken up tomorrow. My lord, thereafter, day after tomorrow, if the matter could be taken.
That is being taken up tomorrow.
Tomorrow, my lord, as item number 1.
I don't mind.
List in the next week. Let's see what happens. List in the next week. Yes.
If they want to file a reply,
My lord, I'll file a reply. Sure.
my lord,
I'm grateful, my lord.
appearance.
You have not filed a reply yet.
No, my lord, I received it today.
Stop. In the meantime, after list in the next week.
Thirteen.
For the respondent.
I am appearing for the applicant. In this matter, my lord, your lordships were pleased to pass an order, my lord, directing us, my lord, to serve, my lord, upon the non-appearing respondents. Now, my lord, we have received an email, my lord, that, my lord, the Union of India and, my lord, the Central Vigilance Commission has to be, my lord, represented by us. But the problem is they are, my lord, as party respondents. So we cannot appear for both. So, my lord, I am humbly beseeching your lordship, kindly, my lord, since we have not sought for any relief against them, kindly, my lord, delete them, my lord, from the array of parties. My lord, we have received the mail to that effect that the same my lord, advocate should represent, my lord, the center, because, my lord, the Bose Institute is an 100% granted institute of Government of India. So, my lord, the person, my lord, who is my lord, appearing for Bose Institute should represent, my lord, Union of India as well. So, my lord, since, my lord, they are respondents, so, my lord, I cannot appear for both, my lord, appellant and respondents. My lord, lordship may kindly delete, because I have not challenged anything, my lord, against them or seeking any relief. The remedy. Lord, the remedy, my lord, we have sought for, my lord, we are challenging the order passed by the learned single judge. My lord, thereby, my lord, quashing, my lord, the inquiry report as well as, my lord, the interdisciplinary proceeding. My lord, it has been set aside. My lord, normally, my lord, what happens, my lord, the person concerned who is appearing for the appellant doesn't appear for the respondents as well, my lord. That is, my lord, the difficulty I am facing.
You have already said, that's what we are asking.
My lord, section, my lord, 15 of the CVC Act.
So along with you, they were respondents for the report. Here we have included them as performance fund.
My lord, I'll just check.
As respondent.
আরে এখানেই থাকবে
They were respondents, not pro forma.
Here they have been.
Here, my lord, they are pro forma. We have made them pro forma. Respondents or pro forma.
So now there is an instruction that they are sitting in the same boat as you are.
No, my lord, I'm sorry, my lord, we have made them respondents since they were respondents in the before the learned single judge. So then, lordship may kindly grant us liberty to correct the cost title. Yes, my lord, kindly grant us liberty, my lord, to correct the cost title.
Is that sufficient? Will that be sufficient? Or something else is required?
My lord, since, my lord, it is not an, my lord, the cost title is not an affirmed portion of the petition.
Given there is the instruction from the Union of India.
Lord, may I have only, my lord,
They will take report.
আপনাদের email ID কি? লিখছে। PIE@gmail.com.
Putting the report. Bring it to the customer.
একটা পেজ দুটো কপি করুন। সেম কাউন্সিল বলা আছে?
On number 4 and 5.
No, but you are representing respond number 4 and 5. Yes. So therefore, only that change has to be made in the cost title. Mr. So-and-so, advocate appearing for
Number 14. My lord. Appellant, my lord. My lord.
I'm appearing on behalf of respondent number 6, my lord.
Who is respondent number 6?
Enforcement Directorate. Directorate of Enforcement.
Yes.
They have served us the copy of the soft copy, but in spite of repeated requests, they did not supply us the hard copy.
Why, sir? Why you are not giving?
I have submitted services there, my lord. Repeatedly sending this, my lord. It has been acknowledged by them, my lord.
No. Give it back. Yes, you are the private respondent in the writ petition.
Yes, my lord. I am the employee. My gratuity has been forfeited.
It has been served on you.
My lord, they have served me soft copy, my lord.
No, sir, it is speed post.
My lord, not received.
My lord, I have sent him the WhatsApp,
Sir,
my
it
lord.
is-
I have sent him
Yes,
the
yes,
email.
yes.
That he is saying he wants hard copy.
They have sent always are in soft copy. Never they have given the report.
All right, this let us argue. You argue this aspect first.
No, I'm sorry, my lord.
What is this?
I'm just saying, my lord.
You should make it convenient so that it can be considered on merit. You want to enroll in this? Go ahead.
My lord, I have done my part of the duty, my lord, and I have, for his convenience, he said that send me the soft copy. I have sent him the soft copy again and again, both through WhatsApp as well as through email. I will serve another photocopy, my lord. That is not an issue, but my lord.
Sir, you are making embarrassing submissions to the court.
I apologize for that.
Yes. He wants a copy, you are making an issue out of it. As if this is the only thing to be decided in this case, whether a copy is to be given or not. Just give him a copy so we can proceed further. Why you are making it an issue?
I do not have extra copy.
So he will get it done. You give it to him. If he has been served a soft copy, then you decide between yourself. We are not going to pass any direction on this aspect.
My lord, the case is not against the my lord. If the case is basically against the employer, and I will serve it today itself. My lord, let the matter be heard. Otherwise, my lord, after.
Apparently, you don't want it to be heard soon. You want to make it an issue whether a copy is to be given or not.
My lord, actually, honestly, my client is in a financial hardness, my lord. That is the reason. Otherwise, I would have served it. Why will I not serve him? Wherever required, we have served the
You
hard
take
copy.
a printout. He has given you a soft copy. You take a printout.
But, only difficulty is this is a voluminous document and have
Take a
part of-
printout. Yes, the learned advocate for the your.
Have passed the order in my favor. One of the honorable single judge below has asked for the ED. ED was not a party in this case.
as because in the minutes it was recorded that ED said none of the employees are involved. So the honorable judge below had asked ED to be a party in it. They had been implemented by the petitioner, and thereafter the honorable judge has asked to file a report. The ED has filed a report wherein it has categorically said that I am simply a witness. No, there is no charge against me. Thereafter,
The withholding of gratuity is by way of punishment.
Because of disciplinary proceedings, but the
pendency or finding in the proceeding.
No, the proceedings has been disposed of, my lord.
So therefore, as a result of penalty.
My lord, as per the Gratuity Act, there is a stringent methodology how the Gratuity Act will be forfeited.
That is, we are just trying to understand what is the issue. So there is some order passed by
some
the
punishment passed.
Yes.
by the disciplinary authority based on which the gratuity is not being paid.
Yes.
You are saying it can't be done like this. Yes. All right. We'll see next week. Give the date at the top of the list. Very good. It will come at the top. Don't seek an adjournment that day.
July 6, sir. And 15.
My lord, if it can be 7 July.
6.
Any day thereafter.
7 July. Hey, much obliged, my lord.
Please inform me.
Application.
15 minute happy.
Much obliged, madam.
Application for
Restoration. The writ petition was dismissed.
can
Yes, but this is can 1. The affidavit of service Panada handing up on it. May, but the matter was dismissed for default, and on the very next day, on 11th of May, but I have affirmed it and filed it. Supplementary
allegation against the
but the fact I was not there. But this is a change brief.
Why are you making allegation against the lawyer? So implead it. We'll have to hear it whether he has committed an negligence.
But I have taken no objection.
Your paragraph, what you have stated. Now you ask us to proceed and consider yourself to be the lawyer in this case on that day. Paragraph 4. Now consider yourself to be the lawyer on that day. Please. This is the way.
But kindly ignore this minute. Kindly.
No, you may comment. You may comment. You will not ignore it. Tomorrow your client will see why the advocate has done it when I have said on affidavit. Or when it has been filed on affidavit.
But kindly, only within 3 days it has been filed. Kindly.
You make amends or you will treat him as a party. That's the only way. There is no other way.
Kindly.
There is no other way, sir.
Okay. But it's
There is no other way. We are saying it for with some responsibility. You have used a word in paragraph 4, you must have seen that word. And the import of that word. You know what it means.
but the
If we are to record that there was a negligence on his part, then in his absence.
no, but kindly.
First of all, how can you say what happened on that day when you were not there on that day?
But it was the version of the petitioner.
How can he say what happened in court? Was he in court?
But probably he has seen in VC.
So now we'll start in every restoration taking the video clip.
But your lordship.
You want to complicate things? Go ahead.
No. But I'm not. But I'm surrendering before your lordship.
No, you need not. You can stand by it or you can make amendment. These are the only two options.
I can.
There is no third option.
But this is the.
You can stand by it or you can make amendments. There are only two options.
Shall I withdraw and file?
We don't know. You decide what to do.
Kindly expunge paragraph 4 and
Not on your saying.
but now I have taken charge of this petition. If your lordship kindly.
This is very unfortunate event that there is a change in the law for restoration and he is asking that question. You are supposed to be filing the application for recall review after obtaining. What are the
with the fresh vakalatnama, my lord, we have filed this petition. So this is dismissed for default.
So your friend has given you NOC and then you are saying he has committed a negligence.
He has not given NOC. My lord, he has, my lord, it's a dismiss for default. My lord, we have filed a fresh petition application. देखिए petition था whether but I have to check because I am not the advocate record.
What are you saying?
May I only check the petition?
After the dismissal in default, you have come into the what with the restoration? It is essentially a recall.
Recall.
Then how can you file a recall?
You see, in restoration application, only the ground for his absence is to be stated.
Yes.
If there is sufficient grounds, yes, courts have the
But
power.
he was not present on that day.
Very well.
But it was
Only the ground of absence, nothing more is
only,
required.
Only. But kindly.
He was not present, therefore it was dismissed.
Yes.
Not being present when the matter is called out can be for various reasons, can also be for negligence. You have chosen to use the word negligence.
But I'm withdrawing that.
In the absence of the learned advocate, we have to record a finding that what you are saying is correct, and on that basis it should be restored. We will not do it.
My lord, your lordship kindly. My lord,
Try to trivialize it, we will
no. My lord, no, not at all. My lord, if your lordship kindly expunge paragraph 4.
No, you make amends or you proceed as it is. Again and again we are telling.
Well, then let me your lordship kindly grant me leave to withdraw. My lord, I'll bring my client and file afresh.
Yes.
Leave to withdraw. I file afresh on the same cause of action. Well, I'll call the client. But may I file a supplementary? Oh, until
Been down there. You don't think such an occasion has occurred in my career as a lawyer? Many a times, after person of using a word negligent. You can say we have all used terms in the restoration that we had asked him, unfortunately, not reach and it was dismissed. Negligent.
But I on the very first word I have said, but it was a mistake. But if your lordship kindly. Well,
mention it immediately.
Very. I'll call the client and
716.
Well, this is that matter, my lord. This CAN 1 is my stay application, my lord.
CAN 3 and 5 are substitution application. Some of the respondents have died.
So they have served this CAN 5 on us, my lord. But we are not standing in the way, my lord. Let that application, my lord. CAN.
If 3 and 5 may not similar substitution, my lord.
This कौन application का बोलेंगे? CAN 5 was served on to us, my lord. Today. CAN 5 was served on 22nd, my lord. I am not standing in the way. It's a formal application for substitution. Let that be carried out, my lord. There's one application of my learned friend, my lord, where we have filed affidavits, my lord. His application is in an application under Order 1, Rule 10, my lord, for addition of parties. Some of the retired workman wants to, my lord, be added as a party, my lord. We have taken oppose this prayer of my learned friend. We have filed an opposition, my lord. I believe they have filed a reply also. That application may be heard prior to, if that is allowed, then
CAN 4.
That's CAN 4. CAN 4. So let this
is the
application be allowed.
3 and 5, my lord. 3 and 5.
3 and 5 was
allowed. 3 was not allowed. Order is not been allowed.
There was one earlier application of substitution, my lord. I believe that was allowed. If
CAN 2 was filed for correction of typographical errors.
yes, that was
allowed.
That's CAN 2. That was allowed.
So the substitution there are CAN 3 and 5.
Let them be allowed. I have no problems, my lord.
Substitution of which respondent?
Respondents, my lord.
Which respondent?
No, respondent numbers, my lord, kindly takes up the application on the first page I have mentioned, my lord. CAN 3, my lord, lordship takes up. They were not read petitions, my lord. They were added subsequently read petition or subsequent to an application made by
respondent number 37 in CAN
9,
5,
13,
my lord.
20, 21, 24, my lord, there are lists.
তাই তো অশোক ঘোষ তো ক্যান ফাইভে ঠিকঠাক এটা একটু বলে দাও না
Respondent number 9.
Yes, my lord. 9, 13,
13, 20, 21. So many. How many respondents are there?
My lord, around 11, my lord. They're all senior citizens, more than 85 years, pension, my lord.
So there is up to 40 respondents.
Yes, my lord. Up to 44 respondents, my lord. Added respondents.
And how many in the other one? This is in Can 3.
Other one, there is one only. It's one.
Can 5. 4 is not required. 5 is 4 is required separately. Can 5.
ऐसे हो गया ये पे I have can 4 है वो तो अलाउ होएगा इसमें तो কোডটা is a different point where file or affidavit ওই affidavit কপিটা আমাকে মানে ডাউন কপিটা একটু পাঠিয়ে দাও মেল করে দিও let me just check once
The final is a tag.
And who is the respondent in Can 5? Who has
Respondent, my lord. I am the petitioner, my lord. Respondent 1 and 2.
no, which respondent is to be substituted in Can
37,
5?
number
37.
37, my lord. I mean, I can give my copy, my lord, if once.
Both copies are served already.
Yes, my lord. Copies.
yes everything has been হ্যাঁ কি হয়েছে হ্যাঁ
Yes, sir.
Can
It has to be looked into, my lord.
Last occasion, my lord, whatever is there in the stay application, my lord, are the records of, my lord, the trial court, my lord, of the writ petition, my lord. If that formality can be waived and we can take
Sure,
up
that
the
can
stay,
be done, my lord. If some
stay
documents
petition
are
and
missing, I can file a
if
compilation.
some
my lord.
documents are missing, my lord, we
I can file a short
file
compilation, my lord, whatever the documents are missing.
Why don't you file it? It will be better.
Fair enough, we'll file it.
Paperwork within 30
We'll file
In the
an
meantime,
informal paper book, my lord, incorporating.
can 3 and 5 allowed?
Oblige, my lord.
Yes.
17.
My lord, item 17, it's a contempt application.
Yes, sir. Order passed by this bench, the earlier bench.
Order passed, my lord, 25th November 2025, page 38.
What is the date?
My lord, my lord,
The
one
order is
thing I
passed
need
by
to
the earlier bench.
Yes, my lord. But the fact remains, my lord, one thing I need to point out before your lordship, that your lordship can look into, my lord, at page 24. Because
we cannot take it out.
If we cannot consider the contempt, what do you want us to do?
I'm sorry, my lord.
The contempt arises out of an order.
My lord, I appear for the respondent. But I was making my submission. So this is where Mr. Shen had argued for the appellant suit for specific performance of an oral agreement. The lordship was inquiring. The point raised by the appellant was that the agreement need not be stamped, and that agreement could also be specifically enforced. And my lord, my argument, lordship has also recorded one of the submissions in the previous.
Where is he?
It's
Not today.
That's what I've seen.
Just tell him not today.
But may I indicate?
It's an assigned matter.
Yes, it's an assigned matter.
So this bench cannot consider it anyway.
Yes.
It is assigned to.
But assigned matter, my lord, assigned, the bench is presided over by your lordship. So my
But
lord, this
anyway,
bench can take
we
it.
have substantially heard it, the other bench.
The other bench has heard it. That is right. But will it be your lordship's pleasure to fix them? Because on last two occasions, lordship had kept the matter fixed at 2 o'clock or 3 o'clock, where we argued. But thereafter, because the adjournment prayer made by the appellant, the lordship did not fix any date yesterday.
Let's see. Let it come in the next week, then we'll see. List in the next week.
If it
that
could retain
bench
its
is resumes, then we'll see.
very well. But if it could retain its position in the list the next week.
Yes. It will come, don't worry. We are
grateful, man.
list in next week. Oh, we'll. Yes.
20.
No, no. This is the entire course of. No. Because in class with also. Yes.
None appears. List on.
Everyone.
Appearing on behalf of the petitioner, appellant. When certificate is coming, this is book number 18.
Section 5 application. Section 5 application copy served.
Heard by the other bench, so we keep it to the next one. On the last day, we had considered it in that bench. We had formulated. With the last order. The condonation was allowed and
Make it short possible. She's coming. She's book number 18.
that proceed short issue. Ah. So it cannot get the other way. Who is for the respondent? None appears for the respondent.
Next one.
Lordship, in this matter, my learned senior is appearing on behalf of the respondent. He is physically incapable owing to surgery last week. So I'm humbly praying 2 weeks.
2 weeks.
Lordship.
Section 5 application.
You have got copies of the documents enclosed with the stay application. The learned advocate, Mr. Not at this time. Sorry.
What happened? My junior.
Not at this time.
Mistakenly said that she was for the appellant, but
Not at this time. At the time of rising or in the morning. This is not the time.
as your
Sorry, we don't.
I'm so sorry.
Lordship, in this matter also same prayer as well.
Yes, same order. You are for?
Appellant.
Appellant is?
Yes.
You just instead of none appears for Union of India, you say Union of India is represented. That's the only difference. And here also copies were to be served.
No, my
Oh, then take down. The learned advocate
24. I am appearing on behalf of the petitioner. Yesterday, your lawsuit asked additional government pleader to consider Mrinal Kanti Das judgment.
You proceed, she will come. Let us see the facts. So death of the deceased is 29/3/2009.
Yes. Thereafter, my
on
father,
that day you were 13 years, 10 months old.
Yes.
And your mother made an application.
Yes.
When?
Subsequently, my lord, after reaching my age of majority, I have made application in the plain paper. They have rejected my claim.
So in the year 2015,
Yes.
you have made an application on plain paper.
Plain paper, but subsequently I have made the application in the pro forma form. That
So in the year 2015, that means after five years. Or less than 5 years. 29/3/2009 is the date of demise, and your date of birth is August 95.
I have made my application 26th March 2014. Your lordship, kindly come to page 26, is a Bengali.
Page 26 of which application?
Writ petition.
Oh, in the writ petition.
26.
23.
26.
26. So it's in Bengali. So no translation made.
No translation made. I've reached while my father died, at the relevant point of time, I was not major. Now I have reached 18 years. I have made this application, and that is 26 March 2014.
That's 3 days before completion.
Page 26.
26.
Page 26. It's in Bengali. So 26/3/2014, the application is there, and the date of death is 29/3/2009. Just 3 days before completion of this 5 years.
So this is made by you.
Yes, Akash Ranjan Rai.
And when you attained majority?
I've attained majority
August 13.
August 13.
August 2013.
2013. And it is within time. My father died by the 29th March 2009, and I made the application in the plain paper.
This application which you are showing us, is this application admitted, or there is a dispute regarding this application being made? No dispute.
No dispute. Only dispute is I've made the application in the plain paper.
No, from where we
That's all that I've shown. Thereafter, my lord,
27, page 27 is for directing you.
27.
Page 27.
Inquiry committee formed, and I appeared before the inquiry committee, and ultimately inquiry committee has passed an order at page 45, and at page 46, the ground of delay has also been explained. Belated request clause. In this case, wife of the deceased employee was more than 52 years of age. Children were minor at the time of death of government employee. In this case, the candidate Akash Ranjan Rai was eligible for employment as his mother was submitted application for employment in his favor. Tania Rai, daughter of the deceased employee, who was also minor at that time. Thus, belated request clause 10AA of 26 EMP dated 1st March 2016, Labor Department, Government of West Bengal is applicable here in respect of the candidate Akash Ranjan Rai, as the government employee constable Vikas Ranjan Rai died while on duty. And committee also recommendation of the committee are recommending the proposal of Akash Ranjan Rai for employment to the post of LDC on compassionate ground under belated clause 10 AA of 26 EMP. On the basis of this recommendation, I appeared before the written examination and also oral examination. In the both the case, I was successful. Thereafter, I made an application why I am not.
Do you have a copy of this Labor Department circular, so that whether we can consider whether what is the letter and spirit of this? They are relying upon this related request Labor Department circular.
Labor Department circular.
You see, they are relying upon this Labor Department. Actually, this is 2016 circular, but the incident took place in 2009. Anyway, but what are the ingredients of that circular?
Oh, 26 EMP. They are referring to 26 EMP.
26 EMP.
26 EMP is of 2000 March 2016.
2000.
This is 2009.
Yes, so that will apply. There is no question on that because the order is passed after that.
And thereafter, my lord, on the basis of the recommendation, I appeared in the examination. I was successful.
No, but they were in EMP 26.
Yes, which one?
Where in EMP 26, there is a scope for making an application after 5 years.
You see, prior to 2016, you made this application. So definitely there were other circulars on the basis of which you made such applications. So have you annexed those?
Yes,
prior to 2016.
Page 37. So for the EMP 26 is
page 37.
Page 37.
Yes.
The time for making an application is 2 years. That you must be aware of. A belated application is acceptable only under the 26 EMP of 2016. If there was no such notification of 16, then your case would have been barred after 2 years itself. So even if you derive sustenance from the 2016 circular or notification, your claim has to be considered strictly as per that. And this circular allows an opportunity to submit within 5 years subject to certain conditions.
Kindly come to page 39. All cases of compassionate appointment should be disposed of by the administrative department, preferably within 6 months of receipt of the report of the 3-man committee, screening inquiry.
That hardly makes any difference right now. See, if they have not disposed within 6 months, you have not raised any issue. You have waited for them to dispose. So now that issue is over. The issue is, it is beyond 2 years. Beyond 2 years, whether it can be entertained or not. Forget about plain paper and pro forma. Even if we don't look into that issue. What are the circumstances under which a belated application is acceptable under the 2016 EMP? It is stated in 10 AA. You do not conform to those requirements. Your mother was available, your sister was available. There were other eligible persons for.
The ground of rejection is not on that ground.
So should we shut our eyes to this provision? That is very much a ground. That is very much a ground. Come to page 55, Annexure P14. They are saying it is not maintainable as a belated request. That means 10 AA is not complied. So don't say it is not a ground. It is very much a ground. They have added a plain paper or no pro forma. That's a different thing. Even if we don't consider plain paper and pro forma, will you be considered as one entitled to consideration as a belated request under 10AA? That is the only issue. It's not an issue of pro forma or plain paper.
Kindly come to 10AA, 10A, page 38.
Yes, which page?
Page 38. 10A, related request in exceptional cases such as death during action where none in the family is eligible. Here, my lord, my mother was overage. At the time of death of my father, my mother was 52. And we are minor. I, along with my sister, were minor at the relevant point of time.
Where have you said this? Where is this fact? From where you gather such facts?
From the Grievance Committee report itself shows.
Oh.
In this case, wife of the deceased employee was more than 52 years of age. Children were minor at the time of death of page 46.
Now you are relying upon 10A. This is, you are governed by this circular.
Yes, yes.
At that point of time.
Yes. Then I am entitled to get 5 years time for making application.
No, this 2 years time as per this circular, you are relying upon. In 2014, you are governed by this circular.
Yes. 10AA. Kindly come.
Yes, 10AA. Yes.
In exceptional cases such as death during action where none in the family is eligible, department can consider request for compassionate appointment even where the death or retirement on medical grounds of a government servant took place up to 5 years ago. While considering such belated requests, the 3-member screening come inquiry committee should, however, keep in view the concept of compassionate appointment largely related to the need for immediate assistance to the family of the government servant in order to relieve it from the economic distress. The very fact that the family has been able to manage somehow all these years should normally be taken as a adequate proof that the family had some dependable means of subsistence. Therefore, the examinations of such cases would call for a great deal of circumspection at all levels. The dependent member must invariably attain the minimum age of appointment at the time of consideration.
That means these issues were not addressed by the authority.
Yes.
Save and except that plain paper issue.
Yes, plain paper issue. And my lord, sitting in Justice Supratim Bhattacharya has considered this same point, my lord, where father died in the year 2013. Mother initially applied, thereafter mother fell sick, and thereafter, after 4 years, my lord, mother made an application on behalf of his son, and your lordship considered the same. It is Himadri Chaudhary versus State of West Bengal. Citation WPST 180. Here also, my lord, mother has initially made application because the petitioner was minor. Thereafter, mother fell sick. After 4 years, my lord, in the year 2016, father died 2013. 2016, made the application.
Why you have marked the copy before giving us? Yes.
After had he applied, thereafter he applied. Shipment with what? Before I start watching. There was an order passed by your lordships in February.
March 13 March. Report in the form of epidemic.
There was a report of the February 20.
Accepted.
Yes, we have the report.
Yep.
Yes,
Of the file,
17 to 26. Yes, we have.
that's
Good.
করেছিল। এটা পরে opposite এটা।
He was killed in violence.
Lorry accident.
Accident.
Killed in an accident.
Accident.
Not in violence. Violence service, he died in harness. But
He made an accident.
he met with an accident.
While on duty.
Why not?
Not on.
Yes.
Yes, you have paid him a special compensation of
Yes,
2
that's
lakh.
why he has given compensation.
And he got
So extraordinary circumstances under 10AA, then is required to be considered. How can it not be considered? What is the date of first application by your mother? Where is that? We have been asking.
Ballot 2nd April 2009, page 23. Also Bengali ballot.
No, this is not in dispute. We have
Page 22.
24
Page 23.
24
23, that is
2009.
in Bengali.
2009.
That's January.
So the report only says that compensation has been paid. There is nothing else.
So compensation, I have a report
Any-
with the other monetary benefits
No,
because
that
the report was related to that, how we gave it, that is the report. But then I find that he's been given the other benefits have been given.
There are other reports also.
Chip from the file, I find
It is
a report in the form of Chip, this is a more comprehensive report. I think.
2/4/2009.
3rd December 2025.
2/4/2009 application is admitted in the other report.
because your lordship did not accept the same because at the relevant point of কামনা শেষে একটা হচ্ছে যে তখন ওই ছিলেন না হোম সেক্রেটারি ওয়াজ নট সঙ্গমিত্রা ঘোষ ইজ অল রাইট
There is a report file, right?
It is dated 3/12/25.
This is dated. There is another report.
as because your lordship was not satisfied
Yes,
the report of SP, that's why your lordship asked Home Secretary to file the report.
Yes.
Subsequently, initially that was filed by the erstwhile Home Secretary. Your lordship direction was that he is no longer in the post, therefore he has no authority to file the same. Thereafter, subsequently, my lord,
But Lord,
present
this relates
existing.
But that report relates to the award of special compensation of 2 lakhs. How it was. That
It is your lordship knows whether there is any particular notification or not.
That is
From
the-
that, it appears that it is independent of compensation and appointment. It is the only thing who made accident. Who made accident, they are entitled to get compensation.
Now, date of granting this compensation 2009 itself.
9.
So therefore, today that is not relevant at all.
Yes, not
relevant at all. So we will refer to the earlier report, which was filed on 3/12/25.
In the page 38.
And where is the details of your sister? Oh, that is also held by the three-man committee that she was minor at that.
Yes, yes, that has also been recorded. Page 46. Page 46, Malad. In this case, wife of the deceased employee was more than 52 years of age and children were minor at the time of death of the employee. I, along with my sister, was also minor.
This rejection does not appear to be sustainable because we have already held that pro forma is not required.
Yes.
And plus 10AA, it only contemplates benefit to in extraordinary circumstance. What more extraordinary? He has died, you have paid him compensation.
Malad, we are still in penury. That's why Malad inquiry committee has recommended my
No, that way you have been found eligible. That's a different thing. If despite that, if there was no special circumstance, belated request would not be entertained under 10AA. But in your case, belated request can be entertained because there is no other person eligible, which is explicit from 10AA, and more so because it is a death where compensation has been paid.
That is independent of compensation.
No, that is provided special compensation.
Special compensation.
That is provided.
Not only died in harness, but he made an accident. Kindly appreciate that only the person who made accident, they are entitled to get this compensation. And your lordship also appreciate nowadays 2 lakhs is nothing.
We are saying that is immaterial. We have said that is immaterial what you have got. But from where do you get this 2 lakh is only for those who die in an accident?
That notification,
Yes, your previous report R2. Yes, R2 is the report.
Notification to
This one.
যেটা জজের জানতে চেয়েছিলেন
Who died or killed, injured in violence commission.
For the special consideration.
This is enhancement
Should, this is
and accident. Accident is also.
Yes.
Lordship, this is
R3.
R3.
No, page 6.
Please to sanction allotment
R2
for the above purpose. The purpose is, my lord, sanction of lump sum amount to the legal heir of deceased constable. The undersigned is directed and say that by the order of the governor has been pleased to accord sanction a sum of rupees 2 lakhs as special compensation to the legal heirs of the deceased who expired on
23/9.
Your lordship was pleased to ask them to produce the notification under which provision governor has sanctioned it. That notification.
This is the memo.
Yes, page 6 is the one.
Page annexure R/2 is the memo.
R/2, that is.
You read the top. You read the top of R/2. The question of enhancement of compensation.
That is the notification.
After careful consideration, the governor has decided that this is the manner in which compensation shall be paid, and therefore accordingly the compensation was paid. Because this is of 2000 and the next page is 2009 one.
This is the 2009 one.
In which it has been made 2 lakhs.
এটা 9 এটা আরেকটা এটা ওদের সংগ্রহের জন্য এটা তো আমি এটা করে ব্যাক করে that is page 6 is 1 lakh to be increased to
2 lakhs. In 2009, 2 lakhs. Yes, take. You have.
Same matter, item number 19. Next matter, my lord, only service is to be effected to the my learned friend, my lord, since my lord. 19. And next matter, 25, my lord.
You are appearing.
25, my lord. Only matter, 19.
For 19, Lordship, I beg to appear on behalf of the appellants in this matter, Lordship. Previous occasion, Lordship, learned Deputy Solicitor General.
We'll keep it in the next week.
Lordship, we
can't proceed.
Lordship.
List in the next week. His lordship is likely to resume in the next week. No, next week. List after 1 week. Huh? You have appeared before this court sufficient number of times. In no case we leave it undated. Every case we give a date. Not a single case.
Instead of going before, now starting again, it is 25.
It should be at 2 p.m. When do we have a free day of 2 p.m. on the next week?
Or 25.
No, wait. When do we have a? We can have it on second. Actually, now today there is a third bench. So instead of proceeding afresh, it is better that we.
My lord is
2nd July 2 p.m.
My lord, 2nd July, I am in slight difficulty, lordship, because
yes, you tell
the matters are fixed up, my lord.
You tell us, no problem.
My lord, the week after that, my lord, after 5th, any date, my lord.
7th July. List on 7th July. Yes, 2 p.m.
I'm
25.
25, I put the appellate, my lord. That is the second matter, because the service upon the landed computer is to be traced, my lord, is to be made trace. One paper book, extra paper book is lying with the file, my lord. Then it can be served upon the by landed friend, my lord.
Mediation, what is the issue?
Regarding this pension and pensionary benefit.
2 wives.
The second wife. Second wife son, my lord. Second wife son. Minor son. Or later copy ballot lying the copy by Excel.
You have to serve a copy. Oh, you are appearing now.
Extra copy paper book ballot.
Nothing will allow you to take from the court now. Whatever you have filed, you have filed.
I have filed by the paper book ballot. There are 3 paper books here, my lord.
Yes.
So 1 maybe ballot.
What do you mean 3 paper books?
3 sets paper book ballot.
We don't know. Is it the same or is it different?
2 volumes. 3 volumes.
स्टैंप लगा ये वाला नहीं देना ठीक है ये है वॉल्यूम 1 इसमें स्टैंप नहीं लगा इसमें स्टैंप नहीं लगा the learned advocate Why? What is the magic?
Next week I would not be here, my lord.
Week after that, just after 2 weeks.
Lordship, item number 26. Kindly.
That is not.
My Lordship, item number 26. The state has not been submit the affidavit and sorry, affidavit in opposition.
Wow, what is wrong with the tribunal's order? Tell us.
ম্যাটারটা কল হয়েছে কি? এই ম্যাটারটা কল হলো এটা কোন?
Come to your MA at page 66. What is the date on which the order was served on you? Show from the MA.
My Lordship, I am as per my serial instruction, just saying that the copy has not been served. That is.
Open the brief, see the MA. Just see, tell us where is the, in the MA, which on which date the copy was served on you.
Yes, given that. Yes, 28, 11, 70.
From where you have got it?
Para 5. Para 5. Para 5. Page 69.
No, that's a different date.
The communication by the respondent authority.
28, 11, 17.
This one, decision was communicated to applicant. 6/12/2007. But the respondent, that is 6/12/2007.
Where is the impute?
Like para 6
Page?
basis that
Where is the impute?
he has not annexed probably.
No, no, it must be there.
Yes, yes. 62.
They have done that is why I'm saying 17 they have communicated everything they have written 14. The threshold is not accepted. Nothing.
My senior,
No, sir, no senior. There's enough adjournments. 2 adjournments we have granted. You start, we are giving you all the opportunity. Just see the rejection order. 2005, your father died. Your mother was a government servant. Therefore, you didn't apply for 11 years. When she retired in 2014, you have made an application. And you are chasing that application that a limitation should be condoned. Seriously lacking in bona fides. This facility is meant for needy people, not like you. They have considered everything in the order of 1912-2016. We are not going to adjourn even for 1 minute now. Such persons, prima facie, VRW should be dismissed with cause. This is a luxurious litigation, sir. This is a luxurious litigation. No adjournment whatsoever. Burdening the court with unwanted litigation and trying to snatch up the benefit which is given to someone or is to be given to someone eligible. Not people like you. At the time of your father's demise, your mother was a government servant in service. 10 years thereafter, she has retired, almost 9 years. The income plus family pension plus the interest, everything has been considered. You are not entitled. It is a question of delay. Substantially, you are not entitled.
It is not that you were minor at the time of your father's death. Had that been so, yes.
Whatever it may be, minor or major, when your mother is in employment, how can you get a compassionate approach? Cannot. And you have not disputed this fact, you are only on delay. You swear again.
But I was in court number 7.
Come forward. How do you
But-
sustain such a
But
claim?
there was a direction to file report, my lord.
Forget about report. We are looking at the order.
Uh,
It is, sir,
since my lord,
the wasteful and luxurious litigation. We are today 21 years after demise of this government servant. And look at these facts. You are still chasing this claim, your clients. Business. Why not cost should be awarded?
but, may I come back on any day, my lord?
Nothing, not for 1 minute today. Sorry. Not for 1 minute. After seeing such facts, we are going to adjourn the matter. Never.
But I was under recommendation they will provide report, my lord.
Not for 1 minute, sir. We are giving you all the opportunity. You have more than 1 hour. You can ask. This is not the. Yes, tell us.
Today, my lord, I am
We are
not ready.
condoning the delay. Now tell us.
But today I am not ready since I was impression that they will
Then
file
we
report.
record that we have refused.
No, my lord.
Please proceed or we will record that you have refused to make submission. We are not going to allow. Come to page 62. Read the order. Past in compliance. First, you have approved the tribunal earlier, more than decade after the demise of your father. That day, none appeared for the state. You got an order for consideration. Consideration is there.
That has been rejected 19 December 2016.
Yes, 2016. Then again in 2020, you file an OA. And your mother's date of retirement is 30th January 2014. So therefore, you did not make any application for a decade. You can wake up any day and come and raise a claim. What have you stated in your OA? Let's see what is your arguments in the OA. How you have justified this claim to be made in 2020. Consciously, you have not given any details. Nothing in the application. All sketchy governments.
The only point that it was taken that subsequent notification were not applicable in the case of the petitioner, since they are of notification dated 2nd April 2008 and 14th August 2008, whereas the deceased employee died in harness on 29 July 2005.
Seriously lacks bona fides. Not lacks bona fides. What others are tolerable exercise of power.
And that only 90, less than 90%. But the subsequent circular. So all what you are denying is this circular of 2008.
But the authority have relied on that.
No, what is your ground of challenge? You see, that is, you are earning a very meager income or hardship. What was your ground of challenge?
But
that the authority did not consider.
But the subsequent notification, one point that they have taken into consideration the subsequent notification after the death of the deceased employee, and my lord, the income, my lord, the calculation on the basis of that notification also.
That is not telling. It is less than that.
But that notification, my lord, subject to my lord's kind correction, if these circulars are not applicable, my lord.
Where have you said in your way? Please read that wrong. That wrong circular has been considered.
But At the page 30, my lord, ground number 1, my lord. May I read for your lordship, my lord? For that, the father of the applicant died in harness on 29 July 2005 while he was in service as a work assistant, and the applicant made immediate application in prescribed pro forma for his appointment on compassionate ground under died in harness category due to premature death of his father. Thus, the subsequent notification dated 2nd April 2008 and 14th August 2008 are not applicable. Which applied? Which one applied? But which was prevailing at the time of which one? Which was prevailing? You are here to substantiate your claim. Which one was applicable according to which a person, a family which has an income of a Group D employee will still be granted a compassionate appointment? Just show us. Your mother is a Group D employee in the PWD department on the date of demise. You are also getting a family pension. Now, after getting so much of income, you will still be considered as destitute for the purposes of compassionate appointment. Which circular says so? If the total income exceeds 90%, earlier it was less. So if it exceeds 90%, then only you are debarred. You are getting the salary of a Group D plus family pension. And that's not in dispute. So this application, that's notification, what difference does it make? The point is, when there is a government employee spouse, that family will be considered as eligible for compassionate appointment. That's the only issue here. And this delay, 2005, first OA filed in which year? 2016. Because your mother retired in 2014, you shot off a few letters and approached the tribunal. Wonderful. And then again you kept sleeping for 5 years. Again you file an OA in 2020. The pattern suggests that it is a luxurious litigation. You're taking a chance. Let's see what can be done. You're not here to enforce any right because you have not disputed that your mother was in government employee. And you want time, as if that will change anything. Yes, take down. Heard the
Paragraph 27.
Please, Your Lordship, my lord. Well, I'm for the petitioners, my lord. On last occasion, Lordship was pleased to direct to serve copy. Now, I have served the 5 copies, my lord. The petitioner before Your Lordship, my lord, they are the driver.
Was?
They are driver of the Civil Defense Volunteer Force, my lord. He was appointed in the year 2011, my lord. And last 15 years, they have been working in the said post, my lord, prudently, diligently, and to the best satisfaction of the department, my lord. As such, my lord, the appointing authority, the commandant, my lord, recommended their names for regularization in the vacant post of the department, my lord. They did not. As such, my lord, the petitioner made
working since
1st of April 2011.
Continuously
till date, my lord. And they are getting, my lord, salaries, my lord, the benefits, service benefits.
There is this statement in your OA that they are working continuously without any break or interruption.
My lord. Page 5, my lord, in the writ petition, my lord, page 5B, my lord, the petitioner stated that the petition was engaged on so and so by the respondent as driver under the West Bengal Civil Emergency Force in the year 2011 in the Department of Disciplinary and the Civil Defense Government of West Bengal, the district of Howrah. And the petitioner has been working in the said post of the force, prudently, irregularity, with satisfaction of the commandant West Bengal Civil Officer has to discharge emergency duty in various types of works like rescue and service, carrying national volunteer force to one place to other as per order of the commandant. And C, my lord, page 6C, my lord, that your petitioner states that the petitioner has been working till today in the said department without any break. And the recommendation, my lord, page 7, my lord, para E, my lord, the commandant recommended the name of the petitioner for regularization, my lord, on 25th 6, 2013, 14, 16, 18, and also 18, and also 18, lastly, 18 February 2019, my lord. Thereafter, the petitioner, my lord, made the representation before the authority jointly, my lord. There are 5 members. Before the authority for consideration their case in accordance with law. They did not, my lord. Thereafter, the petitioner made another representation in the form of reminder that is also not considered till date, my lord. As such, the petitioner filed the application way before the Honorable State Administrative Tribunal, my lord. In the State Administrative Tribunal, my lord, the Honorable Tribunal directed to file the AR and also the rejoinder. That was made. In the opposition, my lord, paragraph 8 of the my lord, opposition, my lord, they have clearly admitted that the petitioner's appointment was made through a selection procedure. They made the application my lord, interview letter issued, and also they appeared and they have given the driving test. My lord. Lastly, my lord, the Honorable Tribunal was pleased to refuse the prayer of the petitioner without passing any order, my lord. That is page 119, my lord. 19, 20, and 21.
Yes, where is that admission that there was a selection, proper selection procedure? In which para you said there is an admission?
My lord, I am coming, my lord. Please, their position, my lord. My lord, for a moment, my lord, allow me. Page 87, my lord. Is 87.
87 is your rejoinder, not their reply. That cannot contain an admission. That is your rejoinder. That's not their reply.
My rejoinder.
Yes. Where you said there is an admission in their reply.
Rejoinder, fit. Page 79, my lord.
Yes. Read paragraph 8. We are at paragraph 8.
Having a reply on behalf of the respondent. With reference to the paragraph 6b of the state application, I deny all contrary statements except those are matters of record. I say that in the year 2008, no direct recruitment was made by the department for the permanent post of driver. The applicant was called.
Yes, he was called for a driving test and taken in. That is a proper recruitment process. There is no such admission in the reply. There is no such admission in the reply. He came, he was asked to give a driving test and he joined. That is their case.
My lord, they have given the appointment through
so they have not admitted. Now anything else? You have been working. They say that for few days you are being paid on a daily basis. You don't have a proper monthly salary. As per work you are being paid. As it is, just see the way you have been recruited. Can we legitimize such a thing?
They made the application.
By a court's order, it can be enforced. You are still working or you are...
Still, I have been working and getting salary. My lord, I have submitted 3 of the judgments, my lord. One of them, my lord, in Dharam Singh case, and considered the case of Jagu, my lord, also. And in the similar circumstances, my lord, their case has been considered by the Honorable Court of...
Read which paragraph you are relying upon.
In Dharam Singh case, my lord, this is in toto, my lord.
So just show us how it is in toto, please. You are here to show us.
Paragraph 4, 7, 9, 11, 13, 16, 17, 18.
How it is covering your case, please read it. Which paragraph you are relying upon?
I have submitted, but...
Yes, we have the copy of the judgment. Therefore, we are asking you to read.
Copy. In this case, they were also the daily wages, my lord. And there was no recruitments, rules, my lord. Court says, my lord. In spite of that, as soon as they have discharged their duties, my lord, in the permanent post, my lord, in the vacant post.
There is no such averment in your case. There is no such fact in your case that it was made against any permanent post. There is no such fact that there was any assessment of your qualification or any kind of a recruitment process which can be said to be having any semblance with Article 14 or 16?
My lord, my respectful submission, my lord.
These things are absent in your case.
My lord,
Plus, there is no continuity. They say that we have been paying as per work. There is no. So how you are bringing it within Jago, that we are trying to understand. Let's see.
My lord, may I place the paid voucher, my lord, the salary voucher?
Yes, you may. How many have you annexed?
My lord, I have annexed in the, yeah, my lord, this is there. After that, my lord, this is 4/11/2025, my lord. These are the paid vouchers. And may I place, my lord? May I hand over?
Yes. No, if it is not part of the record, we are not going to take it. Sorry, you show from the existing records. You have marked your annexures in the OA as ABCD.
My lord. P1, P2. They are the systems for, my lord, for obesity.
Yes.
Their cases, my lord, in Umadevi, my lord, the classification made in the case of Dharam Singh, my lord, the irregular service or the illegal service. But the case of the petitioner is not illegal service. The authority, my lord, recommended their name for absorption. Wherever there were so many vacant posts, my lord. Lord, kindly from the annexures, and also they have given the training, my lord, trained soldier. Annexure E, my lord, E is the continuation of the recommendation, my lord. Even after, my lord, the present eligibility of the driver, my lord, they have also fulfilled. Initially, they were the CD volunteers. They were work as CD volunteers. Thereafter, they made the application, my lord. And then they received that they called for. And on the basis of the recommendation, they made the representation, my lord. This is Bengali document, my lord, that I have translated and submitted pursuant to your lordship direction, my lord. Thus, the petition was not considered till date, my lord. Sorry.
Yes, we have seen the judgment of Jago. Where is judgment of Dharam Singh? You have given us earlier.
Earlier, yes, my lord.
Just
But
let them
this
must
is
be here. Just let us see. Yes, we have got it. Which is the earlier judgment? Which judgment is earlier, Dharam Singh or Jago?
Jaguar earlier, my lord.
Jago is earlier.
Jaguar has been considered in the Dharam Singh case, my lord.
Yes, what was your prayer before the tribunal to consider your application?
My lord, my lord.
Which page, please?
I'll give you. Because the Honorable Tribunal, my prayer was that page 41, my lord.
Page 40.
Point the applicant regular post of driver or under the respondent. Close West Bengal admissible page plus. That's all. Direction.
41.
Page 41, 42, my lord.
No, you are asking for straightaway appointment. You see, court or tribunal cannot direct straight appointment. The authority has to decide your representation.
So that has not considered till date, my lord.
So your grievance was they are not appointing or they are not considering your representation.
Both the prayer are there, twofold prayer, my lord.
Where is that prayer for considering your application? Where is that prayer for considering a representation?
My lord, in the writ petition, my lord.
No, not in the writ petition. You cannot improve at every stage.
No.
We are considering the tribunal's order on the basis of your application, not on the basis of the writ petition.
My lord, pardon me, my lord.
Yes.
My lord.
From the original application, show us.
From the original application?
There is no such prayer.
Under the age bar,
Necessary orders
not to disturb the service of
that is a positive direction. That cannot be best it can direct consider it is we cannot then consideration of the representative. Necessary order to regularize how we can have such a proper order of condition. The prayer can be voted on in complete jurisdiction.
Your very entry in service is the least said the better. We are only thinking that if we reject, what will be your fate? That is why we are thinking twice.
That will be a great banter, my lord, for the.
Just imagine, just because somebody.
Kindly consider the prayer of the petitioner, my lord.
Because someone likes your face, he asks you to come and give a driving test and he appoints you. And all those who are outside, whose face are not so good to the employer, they will stay outside. There is nothing, there is no semblance of any
Is the recruitment process complete? All vacancies filled up?
No, my lord.
No, the recruitment process was done. We did not appear. That is the state's contention.
Oh, there was a recruitment process also.
But you did not participate, so all posts are filled up.
No, my lord. No, my lord. During the
74.
There was applications were invited.
Okay, when was this?
This was in 2021. This is pursuant to a notification. 29th of January 2021.
And you chose not to participate.
That is the problem. They chose.
All the more worse for you.
They chose not to participate.
That further undermines the bona fide.
My lord, during the pendency of this original application, my lord, there was a circular for filling the posts, some of the posts, my lord.
So all the posts are filled
No,
up?
my lord. Till that, we have been working, my lord.
We have been working at this no post. Don't say we are working. Your working does neither affect the advertisement nor the post. There were vacancies which have been filled up by a recruitment process. It It is not a case where the authorities are choosing to perpetuate adulterism. They have taken some work from you and then they have opened a recruitment process which you chose not to participate.
My lord, for this,
Case, but they are not making any regular appointments and they are choosing to perpetuate an adulterism. And on your shoulders, they are trying to fix their budget.
my lord, kindly consider.
Here they have gone for a regular recruitment process.
My
Yes,
lord,
how many incumbents are there like this, just like the petitioner?
5, my lord. Before your lordship, 5, my lord.
5 persons.
Depends, Lordship.
All are working.
That then I have
Yes.
specific instructions on that. But there was a advertisement for 169.
Yes, that where is the basis for appointing such volunteers? Which provision?
Lordship,
To give this authority such a description that you can pick up
find
anyone.
that application.
Yes.
The 29th of January 2021, Lordship, Lordship will keep it and I shall have.
You want to see?
And how many are working with similar fate?
That, Lordship, I find it instruction.
Anyway, take instruction with regard to that also.
How far the Supreme Court judgment will help them. Cannot help them. Whether we can help them. Should try to throw them. Somebody like that. The Supreme Court.
2 weeks.
This is a copy of the civil defense policy.
Yes, nominates after 2 weeks. Yes. My lord, 28, 29, 30, and 31.
Yes, there are 4 or 5.
5 matters, my lord.
Time we have worked with him, therefore we are in a position of the should also take instruction from your client.
They have lost their golden part of their life, my lord, for the cause of the country, my
They
lord.
have gained a lot in their golden part of their life, while others whose face were not so good face, they remained as it is. There are 2 ways of looking at it.
My lord, 1700, only 17,000, my lord.
What do you mean only? Look at those who don't have even that 17,000. You are a very fortunate few.
Some
officer like
500, my lord, per day.
Anyway, you let your learned friend take instructions.
Yes.
Thereafter, it can be seen.
I have the similar prayer. I'm praying the same order, my lord, up to.
Common order is not.
Thirty-two, my lord, I am praying for time service has not complete upon the respondent, my lord.
Service is not required. Let us see.
That advocate on record also not come today, my lord. That's why.
Okay.
You have copies?
Oh my God.
You have got a copy? The learned AGP.
Seven.
33. Petitioner. Lordship. আপনি কর। Lordship.
Take it, wait.
Uh, 71, 33. 33, 171.
Correctly flat.
So 40, sorry.
এই যে এখন তো আর আপনারা নেই তারা
But unfortunately, when did the gratuity fall due? I beg to appear on behalf of the petitioner in this matter. When it became due? Lordship, in petitioner husband died in December 6, 2008. December 2008? Yes, that is when the petitioner's husband died. And his lordship may pay the order September of 18/11/2025. Lordship has concised the entire matter into how much will be the amount of interest. Lordship may takes up order dated November 18, 2025. Yes, you have to produce something.
Lordship, could I just see the
Please see the order of 18/11/2025.
18.
To that order. May I just may I just recapitulate the
Okay.
a very short issue is there.
তুমি আমাকে না এটা কপি সেটা দিয়ে দেবে।
8% interest they are getting. So they are not satisfied. So there's a gratuity provides
That you
the
will,
rate of
that you will kindly give me some extension of time to
This payment is under the scheme or under the Payment of Gratuity Act,
It's under the scheme. Not
government, state government scheme,
it is under
DCRB.
Yes.
Under DCRB, there is no provision
No, Lordship.
for interest.
If Lordship may produce one judgment of this honorable court. Lordship,
Yes, what is the judgment?
in the
There is you have the opposition.
Lordship, I don't have any papers. I was asking him for a copy
in
of
the last 3 or 4 occasions, the
I
respondent authorities have served an advance copy of the opposition affidavit in opposition, but unfortunately they were unable to file the same. They also requested your lordship to provide an order that they can reaffirm the same as as it was misplaced, I believe.
now, Lordship, my learned friend will have to help me out with the advance.
So this is a case where the learned judge directed release on 10% of interest. So actually, you see, the statute, unless it is provided, you cannot claim that the court has to award that much interest.
It is the discretion of your lordship, but lordship, what I'm trying to point out is that in the previous matters, the situation was somewhat of the same condition, and in that the rate of interest was 10%. In this matter,
No, there is in similar cases, authorities have granted 10%.
Yes, Lordship, kindly produce the
That is, he's referring to the judgment.
the judgment. The judgment I have just provided. Should we
That
kindly come to
instruction
the
there.
4th paragraph? The learned single judge, following the directions of a division bench in FMA 725 of 2004 and FMA 731 of 2004, directed the respondent to pay interest at the rate of 10% per annum for the delay in release of gratuity. Lordship, they have given me at a rate of 5% interest.
The authorities.
Yes. My grievance is it will be more than 5%.
No, so question is you are challenging the rate of interest. In these particular two cases, I think payment of gratuity was held up.
Yes.
Thereafter, the court directed interest.
Yes.
But your case is interest already awarded. And thereafter, you are challenging that.
Yes, but they have provided me at a rate of 5%.
But are there any instances where other employees are granted more rate, higher rate, and you are granted 5%?
Lordship, if may,
See, there are three judgments you are citing. There are three different rates of interest granted.
It is the discretion of your lordship, but what?
So what if we say 5.5%?
I understand lordship.
Discretion does not mean an absolute discretion. It is to be founded on some consideration having regard to some relevant factors.
Lordship may kindly.
In one case there is a 8%, in one case there is 9%, in one case there is 10%. Why not we say 5.5%? Or 12% or 18%?
What I'm trying to base upon your lordship is that
where is the relevant provision in the DCRB regarding gratuity? Let us see what it says.
if lordship peruses the 2012 SEC online, in that lordship there is a observation that gratuity is released in terms of death cum retirement benefit scheme framed by the state government, which does not specify the rate of interest. In that lordship, the honorable court has observed that the rate of interest was not specified.
You see, the decisions which you are relied upon, there the gratuity was held up and directed to be released in terms of the order of the court along with interest. But here, your gratuity is not held up, but released after a related period along with interest. So your grievance is not that your gratuity is held up. So directing to release gratuity with interest by the court is one thing, and the interest already awarded by the authorities, and that you are asking for enhancement, that is another thing. Okay, these are the two issues.
Let us see a copy of that which has been served on you, the opposition. DCRB Rule 67 deals with payment of gratuity. Like any other service rule, it says that pension includes gratuity. So gratuity, there is no separate definition. That is standard in all the service regulations or rules. But the manner of calculation and payment is also specified in 67. So they have come out with some, the memorandum dated 24/9/79. The moment we saw 5%, we were of the view that it must be based on some. So if there is already a memorandum of the finance department regarding payment of 5% on delayed payment, then how you can get anything addition? You place this on record. This will resolve the issue. We are informed that.
আমাকে একটু রিসিভ করিয়ে
Item number 34.
34, 35, my lord, your lordship heard me yesterday, my lord. One question popped up, your lordship, my lord, whether this Umadevi's cutoff was to be taken into the 2006 cutoff of Umadevi is applicable. My lord, I have got the judgment of Bholanath. My lord, they were appointed in 2012. And my lord, thereafter the Honorable Court said, my lord, and they are contractual as we are. My lord, same plea was taken by the authorities before the Honorable Supreme Court with regard to the contractual employees, as because they are appointed on a contractual basis. They do not have a right to get regularized. My lord, this plea was taken by them also in this writ petition. My lord, I'm just handing over the copy of the judgments, my lord. The only thing I will be beseeching is, my lord, let me file a supplementary so that I can precisely make the advertisement, the appointments, my lord, the as lord. Then, my lord, I don't mind, my lord. My lord, this is the everything. No.
Lordship, my petitioner serves the copy it because he served it. Lordship, a copy may be.
Well, I've served the GP, I will again serve her. I don't mind for it. But your lordship, kindly have a look at paragraph 4, my lord. That things would be clear, my lord, the facts of the case. My lord, they were appointed in 2012. And my lord, they continued till 2023, my lord, where the Jharkhand government, my lord, went for a my lord, recruitment drive, and they were, my lord, asked to sat down. My lord, that was the issue. My lord, both Jaggo Dharm.
4.1, sir.
Yes,
you read 4.1.
Yes, my lord.
Why can you show such a process in your case?
Yes, my lord. There is a proper selection process, my lord. Advertisement was issued in the website as well as
against sanction post.
Against sanction post, my lord. That is a got.
Where is it shown? From which page you are?
My lord, I have the website copy with me. It's not been annexed. The paper cutting has been annexed in the.
What is not on record, we will not go to. The tribunal has decided on the basis of records available before it. We are not going to allow you to improve the case at the appellate level.
My lord, if your lordship takes up, my lord, page 47 once. My lord, this is.
There was total compliance with Article 14 and 16.
Yes, lord. My lord, your lordship is reading it.
So they have done everything but to give the nomenclature. Here it is a case which you are relying upon. They have done everything for a regular appointment, but only said that it is a temporary.
Contractual. This is case of Bholanath. But in our case also, my lord, we are continuing, my lord, from 2012 and 13 when we were initially appointed, and my lord, till date we are continuing. My lord, there are.
It's not an issue of continuance. It is a question of the manner in which
Yes,
they
my lord, the
were
manner,
taken in.
Yes, my lord. Your lordship will find, my lord, there is a proper selection process which was conducted by the authorities. My lord, this was in the addendum period when PSC, the powers of PSC was taken out by the government and HRB could not be formed. At that juncture, my lord, the government of West Bengal, my lord, in the medical, in the health department, my lord, conducted a selection process, my lord, where the director of medical education was the chairman, my lord, the additional secretary Ayush was the member, director of Ayurved was the convener. And my lord, a selection process was done, my lord, wherein, my lord, we had to, my lord, all the selection process of West Bengal government, my lord, with regard to health services are concerned, are, my lord, no written examination is conducted, my lord, I say. My lord, with regard to the MBBS doctors, the homeopathy doctors, or the Ayurvedic doctors. Now, my lord, still that has been continuing. My lord, we went to the same process, my lord, and we are selected, my lord, in terms of the, my lord, the marks we have obtained, my lord, the requisite qualifications of MD that we have, my lord, we were selected. Now, my lord, if your lordship takes the post with the post were sanctioned or not, my lord, that will be apparent from page 63.
জানি আমায় বলেছে
সেটাই পাচ্ছি
Have a copy.
If I don't have a copy of the petition.
I will serve a copy, my lord. Your lordship will find the rejection orders clearly only states Umadevi. And my lord, they have distinguished with one set of my lord.
What the rejection order says not very. The review are otherwise fulfilling all the conditions based on which this order of judgment has been filed.
I will try to convince your lordship, my lord, that I have fulfilled.
Here, from what we have just seen, there was an advertisement based on roster clearance against sanction posts. Recruitment process for a regular recruitment was conducted, everything in accordance. It is only that the appointment letter said contractual. So in that context, the court considers that for more than 10 years, they have continuously been working. It's clearly a case of irregular, not illegal.
Illegal, my lord. But in the opposition, my lord, in the first
no scope for doubt.
Yes, but in the opposition, my lord, they have said one place that it's an illegal appointment. I'm also that one. I'm illegal appointee, not illegal appointee. Had that been illegality, my lord, Umadevi would have been in my face.
So all qualifications was.
Yes, not. We are all MD doctors. Well, we have the qualifications. We have the experience.
Everything is required.
I will serve everything, my lord.
There is also a certificate.
Next matter is analogous matter, my lord. 30. So both. I will serve copy, my lord, that.
Same order. Same order.
36, but also same order will be required. We have to serve a copy upon them.
We are not recording the order for service. We are just adjourning our press. In the meantime, you take
We'll do that, but lordship will take it after 2 weeks.
Yes. Which case?
36.
36. You are appearing for?
I'm appearing for the petitioner.
I'm for the respondent number 5. I'm for the respondent number 1. And state was.
All right. I'm great.